You could record whenever you just let me know.
It's done.
Welcome back, everybody. I hope that you enjoyed your lunch break. Personally, I went to a pizzeria locally where no one was wearing masks who was working there. But I'm not going to snitch and call the police, although Mary Jo Austin would have done that, I assume, from the fact scenario that we had in the mock arbitration, which was a lot of fun to put together. Before I introduce the two attorneys who are here with me, I'll tell you, they were both instrumental in putting together this fact scenario. I sort of came up with the framework of it, and then both of them sort of gave me their input from their respective sides of what would happen in a real arbitration and what would really be the concerns and things that would come up and make it more realistic. So it was and Keith and Theo and numerous other people also contributed, but there were a lot of facts in the mock arbitration that weren't actually seen there. So it might help for me to lay a little bit of a foundation for that, so you understand, since a lot of this talk is going to be structured on, the mock arbitration. We could easily talk about what we've all been doing in COVID or what our practices have looked like, but that's really not what today's presentation is about. It's really about, really virtual ADR, which is virtual arbitrations like the one we just watched, and virtual mediations. So that's really what we're going to limit our focus to. So the baseline, so much of the hour that hopefully most of you or all of you witnessed was devoted to the arbitrators laying out the ground rules, talking to the sides in that pre-arbitration conference. Now, I think you'll hear from Brady and James that also, and your own personal experience, that it would be atypical to have that kind of a pre-arbitration conference that formally if you were not doing it in a Zoom setting. I hope that you did benefit from watching it, because it is something that you might need for Zoom as opposed to a real life. This is a different venue, which we'll talk about. My partner is actually on his 9th day of a termination Zoom arbitration presently, and there was actually that kind of a in-depth discussion between the attorneys and the arbitrator that preceded that. So I'm going to introduce my panelists. We have with us the union attorney who you saw in the video, Brady Montalbano. I can't talk today. Brady Montalbano Connaughton. Brady was formerly at the Division of Law for the Office of the Attorney General of the state of New Jersey. She spent 7 years there. So she has been on the management side. She spent many of those years as an assistant section chief for the Employment, Counseling, and Labor section. She's presently a partner at Cohen Leader, Montalbano, and Connaughton. There are a lot of law firms in New Jersey with the name Cohen in it. So I'm a management attorney. I've got no affiliation with that law firm, except I've been against them and they're good. The other thing that she does now is obviously represent public sector unions and labor organizations, and that's what she was doing so well in the video. She also represents health and welfare and pension funds. James Rocca, I've actually known him probably 15 or 16 or 17 years at this point. James was 1 year behind me at Boston University School of Law. He also went to that arcane institution that was attended by Keith, the Cornell Institute of Labor Relations, Industrial Labor Relations. Yeah, I'm always shocked because people like James and Keith, they obviously knew what they were doing before they went to school, unlike so many of us, which tells you about the level of preparation. So we'll get into this, but some of the facts, obviously, hopefully you were able to glean them from watching the video. The grievant was part of a meat processing plant. We took that out of the news, obviously. His name was Patty Robertson. He was somebody we also took out of our common life experience in the news, somebody who's vocal on Facebook for opposing policies, yet in his workplace, just like in the news, there were outbreaks of COVID, there were prevention mechanisms put in, they were allowed to stay open, and the accusation was that he wasn't wearing the mask, but there wasn't really solid evidence of that. So I think in real life, as a management attorney in this environment, you have to put on some kind of a case. You have to, try to hold an employee accountable for not wearing PPE. So that was kind of where we came at it. with the converse being that we wanted a case where there wasn't really enough evidence that the employer would seek termination. So we tried to be as realistic as possible. There were some twists and turns of plot that didn't really make it into the video. One was that he was religious in nature, which would have given him the opportunity to say things like contact tracing was the mark of the beast, and how, you know, we were all on a pathway to hell, and that's another reason why in his personal life he's against some of these COVID procedures. That didn't really make it in, but that could have presented another set of facts that could have been interesting. There were other facts that were out there in our fact scenario, but you did see the Facebook post that was the subject of discussion, and we didn't really start talking about it. But what if people liked the Facebook post, didn't like the Facebook post? Could that be mutually concerted activity, which is sort of an NLRB issue that we didn't really get into a ton, but that was out there as well. So let me start with Brady. You know, why did you, first of all, you know, approach, let's start with this. How did you approach that case, and why did you tell me that you thought that a 14-day suspension or something along those lines would be a more realistic, better case scenario for a virtual arbitration?
So in determining whether or not to proceed with video conference arbitration, in my practice and in a lot of practices, the witnesses, and specifically the grievance credibility, is so central, and their testimony is so central to all of the issues, that generally speaking, I'm reluctant to have that individual's quote unquote day in court be by video conference. I want the arbitrator to be able to take everything into account, and just this tiny little snapshot that you can see right now, in my view, does some disservice in a case such as a termination or a very severe suspension. A more minor suspension, I think it can be more appropriate, but I also think that we have to take into consideration as advocates, where we're presenting the grievance, we have to take into consider a lot of different factors to determine whether or not it is appropriate to even be going forward with video conferencing. This fact pattern was fairly simple. It wasn't overcomplicated. There weren't, as far as we could see it, because we knew what the whole fact pattern was, we didn't see that there were going to be substantial issues. I mean, obviously we recorded it, so we only had one witness, but that could have been a case where, this could have been a case where it was a multi-day matter, because Zoom arbitrations do take longer, and management put on their case and they had a number of witnesses according to the fact pattern we had. So those are things to take into consideration, whether or not we're going to be able to schedule the video conference in an expedient manner. Those are all things that we have to take into consideration.
Let me give James a proper introduction, since I got so caught up in introducing Brady. James also, aside from going to school with me and going to Cornell, which obviously is something impressive, I'm notwithstanding my joking. He's probably one of the most, certainly one of the most prestigious law firms in New Jersey. It's known as Gibbons. They're famous, in addition for their great advocacy of having a St. Patrick's Day celebration. Their work that is noteworthy. They also have an outstanding labor and employment practice, of which James is a key member. He spent his entire career, which I followed since we both graduated, representing employers in labor and employment matters. I was first at a national firm, now at Gibbons, which is really a great firm here in New Jersey. So James, how would you respond, I guess, to what you
Sounds is poor.
Sure.
James, particularly the severity of the penalty, is that a concern that you would have with regard to, you'd rather maybe do a suspension case on video, or is that something you can think about?
So, Jonathan, you were a bit muffled there that entire time. Actually, am I clear?
Yeah, you are. I may have to leave and come back in.
Okay.
We'll do that.
All right, but while we're waiting for for Jonathan. I'll just no, there's a lot of echo. Oh, so can you guys hear me clearly?
You're clear.
Okay, great. Similar to what Brady had mentioned, it is obviously my personal preference to conduct a labor arbitration in person. Despite that preference, having gone through this process, I'm definitely more comfortable that a remote labor arbitration can be conducted effectively, provided there are certain requirements that are met. And to Jonathan's point, in a case where there's less at stake for the company and for the grievant. So, echoing a little bit of what Brady said and what Keith said earlier today, I can't emphasize enough how important it is to have a technological platform that's not overly complicated, but it still provides you with the various options that you need. That's, the ability to break out into a caucus with just the arbitrator and your adversary, or the ability to view everyone who's present at the hearing simultaneously. So the Zoom platform that we used, it was very user-friendly and provided us with these options. So I thought, that's obviously a big thing to consider in doing this and deciding whether or not you want to move forward with a remote labor arbitration. You'll see we had very clear ground rules as well. And I think Jonathan mentioned this too, a pretty extensive pre-hearing conference, which is not common in the labor arbitration setting. If you're going to do a remote labor arbitration, I think it's very important that you have, this pre-hearing conference well in advance, in part to test out the equipment. And I saw somebody had a comment earlier about, not just the advocates and the arbitrator making sure that their equipment works, but also the witnesses. So I think both sides should be responsible for making sure that they're using in these pre-hearing conferences and in their pre-hearing meetings with their clients, the exact technology that they're going to be using for the hearing, and that they're in the exact location that they're going to be in for the hearing. This will help obviously make things move smoothly. Sure.
James, if I can just step in, James just said that once you've decided to do an arbitration by video conference, you want to do the pre-arbitration conference via whatever platform you're doing. And I would actually even go further than that. I would say that if you are even considering, before you've scheduled the actual video conference arbitration, you may want to have a pre-arbitration or a pre-hearing conference with the arbitrator, because I think it's really important to determine whether or not the arbitrator, it's important for the advocate to see that the arbitrator is fully conversant in whatever the platform is. As you heard from Keith, I mean, he's been doing this, and it requires a certain amount of control, actually quite a bit of control on the part of the arbitrator. There are things such as, we've been looking at the chat room that everyone can chat in, that can be disabled. And that may be something in an arbitration that you want disabled. Muting people, people talking over each other. You saw in the simulated arbitration, in the hearing component, I tried to make it so that I was talking over James sometimes, and I was trying to get the arbitrator's attention. The arbitrator has the ability to mute everybody, or the host has the ability to mute everybody. And so I think that it would be important, even before, if you're exploring the concept of doing a video conference arbitration, it would be important to have a pre-hearing or a pre-arbitration conference with the two advocates and with the arbitrator ahead of time, so that everyone feels comfortable moving forward. And then you can assess whether or not it is an appropriate forum to be doing the arbitration.
Right, and I'm sorry, I don't know, James, was my intro for you cut? Hopefully I'm better now. Everyone can hear me now?
Of course, my intro and the great things you had to say about me was muffled, but that's okay.
Well, let me just real quick say one thing that's an important point. James is a partner director at Gibbons, which is a prestigious law firm in New Jersey. He's represented the management side for 14 years now. He's been on the management side of both employment and labor and employment law. So he really brings both the technological aspect of being a younger attorney, along with being an experienced attorney. And, you know, I think that was helpful in the fact that he and Brady were both able to kind of play off of each other and work with each other and get all the technological exhibits in. But other people are going to be less familiar and have more difficulty. So I don't know what you were about to pivot to, James, but I saw there was a comment in the earlier chat. Maybe you could address this as part of your remarks. You know, it was great for everyone to see Keith's work, what Keith described on the screen, such as putting the various screen sharing on. But in a real hearing, what do you think about having hard copies of everything, still sending hard copies to the arbitrators versus handling exhibits purely on the computer screen?
I was actually okay with the computer sharing dynamic to it. On joint exhibits or exhibits that the parties are exchanging ahead of time, obviously if they want to do hard copy, that works too. I would suggest that whoever, you know, whether it's the witness or counsel, I think it's important that they do have printed copies of the documents in front of them, in addition to sharing it by screen. But I just wanted to quickly go back real quick to something that Brady had mentioned about having an arbitrator who's familiar with the technology and the process. And this relates to, you know, them sharing the documents, Jonathan, to your point. I can't, you know, doing this remotely is something that I initially was not very comfortable with. And there was a great deal of comfort I received from Keith, knowing that he could control the technology to a large extent rather than having to focus too much of my time on navigating the technology. When your focus in these situations have to be on litigating the case, perhaps more so than ever, because your eyes can't be diverted because you have multiple screens open. You're looking at the arbitrator, you're looking at your witness. So then to add in an additional obstacle that I'm going to try to move people in and out of rooms, you know, you could put your eyes down for a second and, you know, our witness could be reading that note, which we saw, and you might miss it. So I think there's great deal of comfort in knowing that the arbitrator that you're working with not only is familiar with the technology, but to a large extent is controlling it, rather than relying on yourself or your adversary to do so. And in that vein, Jonathan, when labor arbitrations, a lot of it is trial by ambush, particularly as Brady pointed out, you know, credibility is a huge issue for everyone, including the grievant, and management likes to hold on to exhibits for impeachment purposes to make their case. And obviously those are documents that I wouldn't want to physically exchange in advance, and putting them on the screen during the arbitration as the first time everyone gets to see it is the ideal method there.
So, and going to that point, and James talked about this a little bit earlier, one thing that's really important, and we went through it and you guys saw it in the pre-arbitration conference, is those ground rules. Setting those ground rules is so important, and it's really important for all of the witnesses and all of the clients and all of the advocates to have those ground rules, and things such as how the exhibits are going to be dealt with, you know, whether there are going to be hard copies. I tend to think that the screen share is more similar to in-person arbitration, because most of the times I see it for the first time when I'm sitting right there with the party. So those ground rules would all be set in, and how those exhibits would be dealt with would be set during that pre-arbitration hearing. And also, I'm sorry, the pre-arbitration conference. And just going to, you know, I know we're probably going to deal with some of the comments later, but there's some discussion regarding the chat and disabling versus not disabling. That's also an issue that can be dealt with in the ground rules. That'll be dealt with in that pre-arbitration conference. And so the parties can determine how they want that to be set up. The arbitrator can weigh in. All of those things should be dealt with prior to the actual arbitration. When we filmed our different segments, the pre-arbitration conference took longer than the actual arbitration portion itself, because we went through every single aspect of what we were going to do in the hearing. And I would think that a lot of that would be fairly consistent, because you want to get all of those things out of the way. You want to know exactly how things are going to work, what expectations are, so that things can be more streamlined and more, you can anticipate how things are going to go and how things are going to proceed when you actually get to the arbitration itself.
And I'll tell you what's going on in real life, where my law firm and my partner, Jimmy Ploja, are involved now in this 9th day of virtual arbitration. Was not everybody was necessarily on board with the arbitration. The arbitrator was picked or assigned in this case at a much prior date or earlier date. So, it wasn't as though the party sat down and said, well, let's, we're in COVID, so let's go find an arbitrator who knows how to use Zoom, and go through their resumes and read their resume, which one says that they're good at Zoom and which one's not. I assume that many of the arbitrators that are participants in this particular seminar are here to learn more about Zoom and other types of video arbitration, because they may have cases that are pending and one or more of the parties are ready to go, and they don't want to necessarily be the reason why to wait if in fact they think that they can hold this effectively using Zoom. So I don't think that Brady and James are saying that they wouldn't pick an arbitrator based on their video conferencing skills and experience. I think because this all happened so suddenly, right now we're sort of in the first phase of it, which is the arbitrations are already set and they're getting pushed down the line. And then the question is, do you want to go forward with them? But maybe at some point in the future, we might find that there might be settings where you want to do virtual arbitration. Maybe you've got a client with a office down in another part of the country, and they want you to be their arbitrator. So that could be another reason for it. Plus, I think that people are going to be opening much more slowly, depending on who you are, where you are. For instance, it may be that one attorney and one arbitrator are perfectly ready to go with Zoom, but one of the witnesses or attorneys feels that they're not comfortable because maybe they've got underlying conditions that could make their COVID risk greater, or they live with someone along those lines. So is that your experience, James, that right now you've got arbitrations that are kind of sitting on the back burner?
Yes, there's exactly arbitrations that are pending due to reluctance to engage in remote hearings. And there's very good reasons, concrete reasons for preferring in person. Like I said, I'm more comfortable with it having gone through this process. I think it could be effective, particularly if there's not a whole lot at stake. But you can't fully replace being physically present with your client. I mean, for example, physically passing a note during an arbitration is a much more effective way for a client and an attorney to communicate while on the record during a labor arbitration than trying to monitor the arbitration on your screen and also looking at your email, instant messaging, or text messaging to see if your client's reaching out to you to send or receive an electronic note. It's also easier to pull your client real quick into the hallway for a quick discussion when there's a moment of downtime during an arbitration than to announce to everyone that you need to caucus and be placed in an electronic caucus room and then return to the electronic caucus room. And also, as an attorney, part of my job is to try to control the anxiety that my witnesses are experiencing during a labor arbitration process. And there is an extra challenge in trying to comfort someone by phone or video conferencing than there is when you are face-to-face with the person. And you do lose a large degree of control, or at least perceived control, over the process when you're doing it remotely. It's very uncomfortable, and I think that's why there's the reluctance on a lot of practitioners' part to do this. We set ground rules to govern the conduct of witnesses, and you largely need to just trust that those ground rules are followed, and that adds an element of stress to the process that you otherwise wouldn't want to have, because it's much easier to monitor what an arbitrator, what your adversary, and what a witness are doing when they're in the same room as you. And to just tie that into the ground rules, that I thought it was very comforting and helpful that our arbitrator, Keith, basically had a full-fledged, list of ground rules that I thought were very thorough for us to consider upfront, rather than for us as practitioners to start putting it all together immediately. I know at the end of the conference, and there was a few adjustments we made to the ground rules or one or two others that we added, but there was a great deal of comfort in having, for everyone who's a neutral out there, for having the arbitrator come forward with the first take at, this is how I see this going.
I don't know if you know this, James, but in your sidebar with actress Lucille Alfano, character Lou Baker, you actually did comfort her a great deal. So I'm not sure if you know how well that came across in real life, because she did comment to me separately. Actually, I think I was out in the waiting room as she was, and she was telling me, boy, James really made me feel good. He really explained everything. So there is an art form to it. And I think that, if you rewatch what you did, James, that was a way that you can do it and make it more personal on screen versus, obviously you can't be in person, even though you were allegedly in person with her at the plant. But, having that warm, smile, looking into the camera, explaining things to her, I think that went a long way with the client. So it shows that it's not impossible to do that in the virtual format.
And that being said, Jonathan, I mean, that making sure that there is a setup so that both parties can have a breakout room and be able to use that breakout room really at any time is so important. But you also have to keep in mind, it is very, very different from the usual arbitration flow that most of us are accustomed to. I mean, it's one thing to just say, when you're in person, I need to step outside and can I have a minute? Can we go off the record? Can I go talk to my client in the hall? To the arbitrator have to, enable the breakout room, send the parties to the breakout room, and to go over there. It's a very different flow. I think people will have to adjust to it and may not be initially comfortable, but it's something that will require some adjustment, because many of us have done, hundreds of arbitrations or dozens of arbitrations, and it's all been in person. And this is definitely a different way of doing things, and you have to adjust your style if you're going to participate in a video conference arbitration.
One thing I learned from you guys actually was that if you're going to do this type of a Zoom arbitration, it's really important to have your exhibits well marked and well handled. So what James had done, and I think Brady also, was that, they obviously went through the Adobe or Nuance, whatever the program is, to make sure that the exhibits that they had were properly marked. It wasn't just a handwritten, D1 or something like that, or E5 or whatever the case may be. They were, set out. They were ready to be zoomed in on. They were well prepared. They were well organized. So in this type of a hearing, you have to really be ready to go with those types of things, because it's not like you could just pull a piece of paper and then pull it back. Oh, wait, I don't want to show the witness that. You have to be a little bit more deliberate. Would you agree with that, James?
Absolutely. Now, one thing that when I was preparing for the remote arbitration, to your point, Jonathan, that I thought was, I'll be watching or doing this on my computer, so it'll be easier for me to have my notes and to take notes on my computer. That was my initial thought. In my work office, I have two computer screens where maybe I might have been able to pull that off. But at home, I have a laptop with just one screen. So if I try to take notes on my computer, it just would have covered up the video of the arbitration or required me to shrink the video to the point where I couldn't see it. And again, if you're covering up the video even for a second, you can miss something that's critical in this atmosphere. So having a physical notepad present for taking your notes, and printing all documents that you may be using, such as witness outlines and exhibits, and having organized exhibits, to your point, Jonathan. And I also, for arbitrations, I have a document that I keep next to me, which tracks what an exhibit is, whether it's a joint exhibit, whether it's introduced, admitted, if there's any objections, what the objection was, and what the ultimate ruling is. So having those documents printed and next to me so I could write on them rather than relying on the computer screen is definitely critical to this process, having gone through it this time.
Any comment on that one, Brady?
No, I agree. I agree with that 100%. I think, though, it's important for advocates, because a lot of the times we will have joint exhibits that are agreed upon ahead of time, and that can be done together, but the onus will be on each individual advocate to be sure that they're familiar with the platform. They know how, there are certain procedures in order to make sure that when you screen share, you're able to get that document up, make sure that it's formatted correctly so that everyone can see it. You know how to zoom in and out. I would definitely recommend that advocates and arbitrators practice ahead of time, so that they know how to present themselves and do it in a way that it is visible to everybody, so that it'll make things just run a lot smoother.
I gotta tell you, watching it as an observer, fortunately, I did play that cameo role as the transcriber. I don't know if people saw that, but I know a lot of you probably think that I should go into acting from that brief cameo that I made, but I'm going to stick with the law for now. But in my role as watching this as an observer, I have to say that when you're at a hearing and you tell everybody to look at a document, it's almost like you're in 5th grade and the teacher says, okay, now everybody turn to page 52, and you hope everybody's on page 52. But if you're doing this here and you say, all right, let's all look at exhibit, E3, which is the COVID chart or the number of deaths, or it's the grievance chart, whatever, the grievance form, whatever it is, and everybody is there and you want them to look at a particular word, you can, that the arbitrator is looking at it, your adversary is looking at it, the witness is looking at it. So in a sense, it's almost an advantage visually for the experience, that that everybody's really on the same quote, page, unquote. You agree with that?
Yeah, and just to add to that, when sharing on your screen, which is what I learned during this, is that and you all saw it, there may be a delay in others viewing the documents. So during the mock arbitration, I try to share an exhibit from the New Jersey COVID-19 dashboard on my screen, and there was tiny print, and I was trying to zoom in to make it bigger. And what I was looking at and what the witness was looking at for a brief period of time wasn't the same. And I didn't understand that there was a delay. So for a second, I thought that the technology was failing, and then someone could start worrying about that rather than keeping their focus on the exhibit and the question. So knowing that there could be a delay when you're sharing, zooming in, maximizing, minimizing, is also something important, I think, to consider.
And don't you think, Brady, that the impeachment on Zoom is almost more effective when you're representing the grievant and you're basically, defense counsel, and James hits the grievant with this Facebook posting, and now it's all over everybody's screen, and it's got him stomping on a mask, saying basically that he thinks that the work rule is stupid. And he's just gone through testimony saying that he always follows the work rules and he doesn't second guess them, which is what happened on the uncut portion. I mean, isn't that, how do you come back from that? Is it worse than in real life, in a way, because that image is sort of ingrained in your head visually at that point?
Well, I mean, first, I think that's where the advocacy comes in, right? I mean, that Facebook posting, in my view, was completely irrelevant to the main issue at hand, was whether or not he was wearing a mask or not on one occasion at work. But that was all recorded in another section, a section that we didn't get to see for time purposes. I mean, I think there are a couple of things to look at, right? So you're going to be, depending on the ground rules that you set, I may have seen that exhibit prior to it being put up on the screen. That was part of the ground rules that we had set, that I was going to receive the exhibits, the employer's exhibits, just prior to the hearing by email. So I would have had an opportunity to look at it. Had it not been in this mock recording, I very well may have made a motion in limine to have that completely excluded, to have any testimony relating to that excluded. So we could have dealt with that prior to the hearing. I mean, I don't know that it's that different. It is different because you have it right up on the middle of your screen, right? So it definitely does it could have a different impression, but I would expect that an arbitrator would take all of the evidence and make their credibility determination, and give evidence the weight that it's due, without being biased because it was up on the screen. So that, I mean, that's my expectation, and I think arbitrators, that's how they operate.
Yeah, I think that's fair, even though, you know, there's that saying that you can't unsee things that you've seen, and arbitrators are human too. So I wonder, you know, and you probably would need a psychological study on this to find out to what extent the visual presentation, you know, can have a mental sort of effect on the arbitrator that based on how it's presented in what format. Now, Luella Nelson makes an interesting point here, which I think bleeds into the next question that I was going to ask James anyway. She says, where the camera is placed also makes a huge difference. I guess it's more of a comment than a question. I had a grievant in a setup where his face filled the entire screen, I guess like that, something like that. He was looking around nervously. I'm not going to act that out, but there's no way to tell if it was because it was so unnerving to see himself up close. So I guess I'll ask you guys to comment on that, but I also would be interested in what, you know, having gone through this experience now and sort of dissected your own performance and seen it up close, what specific guidelines you would go through with your witnesses that you in prepping them for a virtual arbitration as opposed to an in-person arbitration. And I assume some of that would include those considerations just mentioned.
So one of the things we had talked about was that the witness certifies that there's no one else in the room. And so that's one thing. And I don't think that it's out of line for an arbitrator to ask an individual to pick up their computer or their camera or their iPhone or whatever it may be and do a 360 of the room. I actually can't remember whether or not this was in the mock arbitration, but in the original recording that we did, James asked for the grievant to show his entire desk, and I think I made an objection. But I don't think that that is completely out of bounds for an arbitrator to ask for, to ensure that there is nothing interference, that there is no phone being looked at by the grievant, by someone who is sworn under oath. I think one thing that an arbitrator can do and an advocate can insist on is that despite somebody being sworn and testifying under oath, I think that it is acceptable for an arbitrator and an advocate to request that a witness submit a certification, that there was nothing before them, that they did not consult with anybody while they were sworn under oath. I don't think, if there is such a serious concern about some kind of interference or some kind of impropriety, I don't think it's out of line to do that. In addition, again, remember, the arbitrator is going to be making a credibility determination about that individual. So if somebody is constantly looking down or looking over to the side, in addition to doing a 360 of the room, the arbitrator is going to note that in making their credibility determination.
And it could be a I think what the commenter's point was, though, is that it could actually, you could be trying to read their body language for credibility purposes, but really be misreading it because, in a sense, the person may not be familiar or comfortable in this type of a setting. They're constantly, let's say that they see themselves down in the bottom left-hand side of the screen and there's 7 people, and they're constantly looking to see how they look, or maybe they're not mindful of what they're doing, and, you know, they're just kind of off. And it's just because it's such a different, you know, scenario. Maybe if they were at a conference table, they'd be sitting upright, you know, with good posture and their hands together and making eye contact with the arbitrator and the attorney. But because this is different, you know, couldn't that body language be misread, number one? And number two, James, you know, assuming that that's the case, you know, what kinds of things, I know I'm putting you on the spot, but what kinds of things in addition to that would you want to counsel your witnesses if you're trying to prep them and put them on, give them the best preparation possible? What kinds of things would you say to them besides what would be in a normal arbitration about, you know, getting properly acquainted to this format?
Yeah, I think it's important. Just, you know, these are very practical points that you're asking about. I think it's important that the witness puts on a suit as if they're going to be, you know, in an actual real life hearing and setting. I think just wearing that type of clothes helps emphasize and make you feel like this is a real important hearing, similar to if you were doing that in person. A criticism of myself watching the video, and there's no shortage of it, but the lighting I wouldn't never do that again. I had a stained glass window behind me, and it made it, I think, a little bit hard to see me at times and fuzzy. So I would always, moving forward, do it so that if I had a window, it would be in front of me rather than behind me. So that might be another thing that I suggest to the witness. Obviously, telling them not to have anything in front of them that would distract them, that has them looking around. And yeah, go ahead.
I just think another thing, I mean, I think it's important for the witness to understand that there is the ability to go into a breakout room or to take a break. Just because we're on a video camera doesn't mean, or on a video conference, doesn't mean that we just have to keep going. Obviously, the witness needs to understand that no testimony can be discussed and that they're still under oath. But if somebody needs to take a break, just as in any live arbitration, you're allowed to get up and take a break. I mean, and that may be an opportunity for the advocate to tell that individual, it's okay, just calm down. I know this is something you're unfamiliar with. Another thing that I think would be really important is to prep your witness on video conference so that they feel comfortable. Have your client present. For me, when I'm doing a disciplinary arbitration, my client is the union, and then the grievant is an extension of that. So I would do a prep with both my union client, a business agent, as well as the grievance, so that we can do a little bit of this mock preparation so that somebody does feel more comfortable. And I would encourage my client and a grievant, if they are not comfortable, that we can do it over and over again until they are conversant and comfortable.
Yeah, I agree with that. I think I might give my clients or witnesses who I represent a similar breakdown to what Keith did, which is look at the camera, right? Get used to that. And also be mindful of the fact that you're being watched all the time. So, try to avoid involuntary gestures or things that you're not mindful of, or seeming like you're not paying attention, falling asleep, putting your, slouching, looking down, all of these kinds of things that you might not, you could have very experienced attorneys, actually, frankly, who come off terribly on a Zoom, believe it or not. And because it's just you're not used to, at least I'm not used to being watched or realize I'm being watched the entire time. In a real life scenario, there's so many other directions that people are looking. You can't just anytime you want, just get a screen, of me in my home environment or me in my isolated environment, not cognizant of what you guys are doing. So let's, I guess, hit some more of the chat questions.
Can I just real quick jump in? I think now's an okay time to mention it. When and obviously this was worked into the fact pattern, but when I caught the grievant reading a note, it was a very innocuous note, but I wanted to make as big of an issue as I could of it, because, he clearly disobeyed the arbitrator's rules, right? Credibility is central to these kinds of things. I saw it really bothered the arbitrator that he had done it. And, anyone who needs a reminder to tell the truth, that if there were post-hearing briefs or whatever, I could have a lot of fun with that, which is why I made a bigger issue of it than others might, and trying to get it, preserved and be part of the record. So, preparing witnesses and getting them ready for a hearing, making sure that they're not engaging in any type of behavior like that, I think is important.
Right, and that example was actually a little bit ridiculous because the question asked of him was one that you would expect him to know off the top of his head. What union are you in? Under the fact pattern, he's been in the same union for God knows how long. He's been an employee there for 23 years. He's a shop steward. So that he would need to look at a note that says tell the truth is just incredulous. But at that point, so I don't think you were wrong to get mad, James, but what do? I think that's the arbitrator right now who's with my partner in some other location, basically said, you know what, we'll make people certify, we'll swear to all these things, but ultimately at the end of the day, how can I stop them from emailing, from texting? We're not going to make this, it's just impossible. But I'm with James on that because but at a certain point, where do you draw the line? I mean, you bring it to the arbitrator's attention, but what are you going to do? Voir dire him and basically put them on a stand, swear that there's nothing else in the room, pick up your computer and walk around and, let's look under every single crevice. I mean, at some point, it's just the point has to be made that, hey, look, that maybe this person isn't being entirely honest and forthcoming, and hopefully the arbitrator might make note of that.
I mean, that's, I think, all you can go with. I mean, I think that applies to in-person arbitrations as well. I mean, if someone's going to cheat or discuss their testimony, they can do it in person, they can do it in video conferencing. So if someone tries or wants to try, they're gonna do it. And I think it's gonna be upon the arbitrator to determine whether or not it's sufficient to, to note in an award or to have it count against somebody's credibility.
I think on those issues, you have a lot more control in person. Obviously not 100%. You do have more control, which is why I think these hearings, at least for the near future, we follow our client's lead or decisions. But I would reserve these types of hearings for the less significant types of cases. And just another reason for that, kind of a softer reason, is that we are all in the labor management relations field, and a key word in that is relations. And there really is a personal touch that's important to what we do, whether it's having a good relationship with union officials, your union counsel. We're negotiators, and in the field that we're in, you can't replace that face-to-face being in the same room ever for a long period of time. A lot of this is built on trust, and once that trust is broken, it's very hard for that relationship to be mended. So kind of a long-winded way to just say, I think that these remote hearings, despite how well they can be done and function, can never really replace the in-person meeting and conferencing that's important to what we do.
Do you agree with that, Brady?
I do. And I think it also goes to what I said before in that, a grievant deserves their day in court. And I think, look at our screen right now. Look at your screen. I'm this teeny, unless you have it in speaker view, I'm a teeny tiny little box with a number of other people's involved. So even if you have witnesses sequestered, you still have at least 2 advocates, an arbitrator, a witness, maybe a court reporter. So I don't know that it is the best way, especially in a disciplinary arbitration. I think a contractual violation issue and in a contractual grievance is a little bit more straightforward, but I don't know that it does the best service to our advocacy and to our clients and to grievance to be doing disciplinary arbitrations by Zoom. That's my personal opinion.
And let's not forget that the labor arbitration process really is nothing more than an extension of the collective bargaining process. I mean, that's really what it is. And particularly if you have contract interpretation cases where, if you have an arbitrator that's worth their salt and it's a major issue, they're going to use every tool that they have in their toolkit to try to get the parties to resolve this and come to a amicable resolution through negotiations. And that's a lot easier when you have 2 people that you could force to be in the same room together than have them hearing and doing this remotely.
There are some obviously statutory arbitration cases. So I guess I'll ask Brady the obvious question. Would it make a difference if it were, a statutory arbitration, such as maybe an ERISA arbitration case, or if it were a teacher tenure case, something that's compelled by statute? And I'll throw in a factual scenario here, which is actually realistic under New Jersey's public employee laws, which is that if the employee who's say suspended pending termination is perceived to be delaying the process, that basically the 6-month limitation that they could be kept off the payroll is waived, and or it can be told, and the employer can keep them off the payroll longer. So in other words, you could be in a position where the employer and arbitrator say, hey, let's go forward with the arbitration, and you say, I don't want to do it on Zoom, I want to do it in person. And then the management attorney says, Well, if you demand doing it in person, that's fine, as long as you agree that that the aggrievant is going to be off not even the aggrievant at that point, the statutorily terminated employee is going to be off the payroll for however long that you caused this thing to be stalled.
I would never agree to that. I think it remains to be seen what is applied in this pandemic circumstance. I mean, it is exceptional circumstances. And I certainly would not agree to that. Your question about, an ERISA arbitration, I don't know that I really have a problem performing that kind of an arbitration via Zoom. A lot of it is very document heavy. I mean, a lot of joint exhibits. I don't know that would be so problematic. I think that it's a little bit more straightforward. When you're dealing with specific employees and any kind of disciplinary charges, I think the argument is better to have the in-person. And I will tell you that, we're starting to see loosening up now. I have in-person arbitration scheduled for July. Obviously there needs to be, social distancing is still being required, a limited number of people in the room, certain spacing, and sometimes that's just not possible given facilities that are available to the parties. But I know in one specific circumstance with one of my adversaries, there's a very large conference room. There are multiple breakout rooms. So that, that is possible, but that where possible, I would fight being compelled to be going to arbitration in any kind of a disciplinary matter.
Well, let me ask James this question. You bring up the fact that arbitration is in most instances part of the collective bargaining agreement, which is why under the Federal Arbitration Act and corollaries to it, it's almost impossible to vacate an arbitration award, much to the happiness of many of the people on this Zoom call. To what extent, though, that those very narrow windows by which an arbitration award can get overturned are sort of invited for you to find more problems with the arbitral process now that you've got a whole recording on Zoom and what's missing, what's on it, what's not on it. You can not only could there be a stenographer's court transcript, maybe there's not one, but you get to watch the entire video over and over and be able to try to find things where maybe the arbitrator is too chummy with one person or another, too hard on a witness. They seem, whatever these, various exceptions are whereby you can get an arbitral award vacated. Is an arbitrator at greater risk that an advocate's going to pick apart their arbitral process because they've got the whole thing on Zoom?
There's probably a slightly increased risk of that, I guess, just because, like you said, you now have or could have video conferencing where it's easier to pick apart little things here and there. But, by and large, I don't think that's a huge concern. There's, unless somebody's doing something very egregious, if it's egregious enough that it's going to warrant the vacature of an arbitration decision, whether it's remote, in a remote setting or in a live setting. I think that's not really, I understand your point and your concern, but practically speaking, I just think it's a slightly increased risk, frankly.
What do you think, Brady? Am I off base with that one? I'm just trying to figure out if there's any, it's not really a concern. It's more that I've been in situations where I've tried to get arbitration award vacated and there's no way to do it. But maybe if I've got this arbitrator on screen who disclosed that they've got some sort of relationship with the other counsel, but they didn't disclose it to the same level that I think they should have. And now I've got some Zoom conversations that are on the recording where they're talking about, seeing each other down the shore later because the two of them, belong to the same country club, any of that kind of stuff.
I mean, I guess you're free to make that argument, but if you hear that in person, is that going to be sufficient to meet the standard to begin with? I mean, I think it goes back to those original ground rules and whether or not we're agreeing to have the Zoom platform recording be given to the parties or to the attorneys or the advocates, or if we're just having a transcription. I mean, even if you have a transcription of the full proceeding, if that was said on the record, you would have that on the record. But I think that, and I think Keith made this clear, and maybe he'll speak about it some more when we all get together in the ethics roundtable. But I tend to think that it's not that helpful for the parties to have the Zoom recording. It would be better to have a transcription. Now, in my practice, the union generally does not order a transcript because we don't usually do written briefs. I generally close orally, and that's kind of the end of it. So in that kind of a situation, which I probably wouldn't agree to a very complicated issue being done via Zoom arbitration or video conference arbitration to begin with. So I don't know that it's necessary, and the arbitrator would control whether or not Zoom can be, the arbitration itself can be recorded, whether it be locally or on the, by the arbitrator. So, I don't know that it's going to be an issue. I mean, if you hear something said, you're going to raise the issue whether it's on Zoom recording or not, right? I would assume.
Yeah, real quick, James, just because this question has come up. I know that you said on the arbitration that it's not your normal practice to have a transcriber. Now, kind of looking back at this with hindsight, in a case like this one or in another case, would you imagine that you would want a court reporter?
On a 2-week suspension, I don't think so.
On a termination case or a contract case?
Contract case, it's much more likely that I'd consider it. On termination, usually not. Again, unless the client feels strongly. Yeah.
Why contract? Just because it sets precedent, or why?
Yeah, absolutely. Contract cases, dictate, the future direction of the relationship on that issue, at least until the expiration of the agreement, sometimes longer. So.
And I really think it has to be considered on a case-by-case basis. I mean, there can be some not that complicated contractual violation issues that you may not need any kind of transcription for. I really think that the advocates would have to determine on a case-by-case basis, and then also decide, there's a significant cost to having a court reporter in a transcript, and some clients, quite frankly, are not willing to put that forward and pay for that. So, obviously, those are all considerations that have to be decided.
Yeah, one last point on that. To the extent I think that there might be other allegations, or there are other allegations that this individual has made in other proceedings, whether it be court or administrative, that might be that might be a reason in a termination case, for example, that I'd be more likely to want a transcript.
And another situation, just real quick, I know we're wrapping up, I'm sorry. Just something to consider for the parties to consider is interpreter services when there's an interpreter to be involved, because I have a lot of clients that are not English speaking. That is something to seriously consider. And if you're going to have a video conference arbitration, I would definitely want a transcript in that kind of a situation, but it would be very difficult to conduct a Zoom arbitration with an interpreter present because of the lag time.
Great. I want people to have an opportunity. I don't know if they'll have much of one to grab a coffee or get a break before the Theo starts at 3 o'clock. So I don't know if James, Brady, do you guys have kind of a 1-minute summation you want to give about, what you take out of the process? If you don't, that's fine, because then people could get a break for a minute or two, and you'll be back with me later on.
Well, I think if anybody has a question or anything, I mean, they can email us personally or send us a message in the chat.
All right, so you'll close in writing then?
If requested, yes.
Okay, great. Well, and I'm asked that anybody who is trying to get CLE credits at this point, and this isn't political because this wasn't my idea, type in trust but verify. 3 words, trust, B-U-T, but verify. All right, that way we know that you were here and you listened to me, Brady, and James in our freewheeling discussion. And then come back at 3 o'clock, or don't leave, and we will be on for Theo talking about mediation. Theo Chang on mediation.
The emperor after all, and we're but a bunch of old men rattling on about tradition and honor. but I've known Commodus since he was a